All rise, we will obey. The International Criminal Court is now in session. Lord John to Kupana International to it. Please be seated. We will swear.
Good morning, Madam President, Your Honors. The situation in Uganda in the case the prosecutor versus Joseph Kony. Case reference ICC 0204 0105, and we are in open session.
Good morning again, everyone. Let me welcome all of you here, those who are physically present, as well as those who are joining us remotely. Today, the chamber is comprised of, to my left, Judge Hakel Ben Mahfoud, and to my right, Judge Yulia Antoinella Motok, and myself, presiding Judge Althea Alexis Windsor. We have already on record the appearances. We see we have the prosecution represented. We also have the CLRV represented. Would the defense wish to put on record their representation?
Good morning, Your Honour, and thank you for that kind invitation. Indeed, we would. You know that my name is Peter Haynes, and I'm counsel assigned to represent the interests of Joseph Kony. I'm flanked today by two members of the Ugandan Bar, two defence team members. To my right, Jeffrey Boris Anyuru, and to my left, Atim Liliane Beatrice. Behind me is my associate counsel, Kate Gibson, and one of my case managers, Anouk Julien.
Thank you, counsel. All right, very well then. The hearing for the confirmation of charges in this case is now open. The subjects of today's hearing is the prosecution's request to confirm the charges against Joseph Kony. At this stage of the pretrial proceedings, the prosecution alleges that Mr. Kony is responsible for the crimes as listed. This pretrial chamber will not decide on the guilt or innocence of Mr. Kony at this hearing. Pursuant to Article 61(7) of the statute, this chamber's duty is to determine whether there exists sufficient evidence to establish substantial grounds to believe that Mr. Kony has committed the crimes for which he has been charged. If some or all of the charges are confirmed, a trial chamber will subsequently decide on the guilt or innocence of Mr. Kony. This case is the first at the International Criminal Court where the confirmation proceedings and hearings are held in absentia, in the absence of the suspect, pursuant to Article 61, 2b of the Rome Statute, which sets out the requirements for holding such proceedings. On the 29th of October 2024, this chamber decided that all the requirements set forth under Article 61 2b were met, and this still holds true today. In this regard, it is important to note that trials, unlike confirmation hearings, may not take place in absentia. That is to say, if the charges are confirmed, a trial will not take place in the absence of Mr. Kony, who has the right to be present at his trial pursuant to Article 67, 1d. In several decisions leading to this hearing, the Chamber has clarified that the in absentia nature of these proceedings requires few procedural adaptations vis-à-vis confirmation proceedings held in the absence of the suspect. Those adaptations mainly pertain to the early stages of the proceedings and do not generally apply to the framework governing the confirmation hearing. Accordingly, the following general principles apply to the present hearing. First, in accordance with Article 66 of the statute, the suspect shall be presumed innocent until and unless proven guilty before the court. Second, the burden of proof rests squarely with the prosecution, which as a result will have to provide sufficient evidence in order to prove the charges brought against Mr. Kony to the relevant standard provided in Article 61(7) of the statute. Third, the defense will enjoy all the rights enshrined in Articles 61(6) and 67 of the statute. Although Mr. Kony is not before the court, his rights are ensured here by his counsel, appointed on the 21st of June 2024. It is also recalled that while the general rule is that this hearing is public and therefore should be held in open session, it may occur with a view to protecting private or confidential information, particularly regarding victims and witnesses, that parts of the hearings may be held in private session. The confirmation hearing will take place in accordance with the schedule set forth in the order setting the schedule and directions for the confirmation of charges hearing, with one clarification with respect to the lunch break on Wednesday, the 10th of September, which you will be informed of accordingly. In any event, the schedule provides as follows. 30 minutes are set aside for discussions in relation to observations under Rule 122(3) of the Rules of Procedure and Evidence, if necessary. The parties and participants have 30 minutes each for opening statements. The prosecution has 3 hours to present its arguments on the merits. The CLRV have 1 hour to present their views and concerns on the merits. The defense has 1 hour to present its arguments on the merits. The prosecution has 30 minutes to present its final observations. The CLRV have 1 hour to present its final observations, and the defense has 1 hour to present its final observations. I wish to remind the parties and participants that oral submissions must be concise and ought not to repeat any argument previously set out. Final statements may not be used to raise new arguments, but only to respond to arguments and questions raised during the hearing. I further draw the attention of the parties and participants to a few technical matters. The parties and participants must ensure that their microphone is turned on when speaking, and I add, turned off when not speaking. This is to facilitate interpretation and transcription of the hearing. Speak slowly and pause for approximately 5 seconds before answering any question or after each sentence. And please try not to interrupt each other. The parties and participants shall clearly indicate whether their submissions can be presented in public session or whether it is necessary to move to private session. Similarly, whenever parties and participants refer to evidence, they must indicate its level of confidentiality and specify whether it can be referred to in public session or private session. When in public session, parties and participants shall refrain from mentioning the names of victims and witnesses and instead refer to them by their respective codes. At the conclusion of the confirmation of charges hearing, the parties and participants shall provide a list with the items of evidence referred to during their submissions to the chamber by way of email. So having dealt with these technical issues, I next turn to Rule 122, one of the Rules of Procedure and Evidence. This provides that the court officer shall read out the charges as presented by the prosecution in an abridged version of the document containing the charges. The full version of the DCC is publicly available. I recall that the DCC contains the allegations of the prosecution. The chamber will assess and consider the evidence presented by the prosecution to see whether it suffices to confirm the charges. Court officer, you now have the floor.
Thank you, Madam President. The prosecution brings 39 charges of crimes against humanity and war crimes committed by Mr. Kony between 1 July 2002 and 31st December 2005 in northern Uganda. Charges 1 to 14 concern crimes committed by Mr. Kony as an indirect co-perpetrator jointly with and through RA fighters pursuant to Article 25(3)(a) in relation to the attack on Rwalagers Senior Secondary School and the 7 IDP camps of Pajule, Abia, Balonyo, Odek, Pagak, Lukodi, and Abok between about 10 October 2003 and about 8 June 2004.
The speaker slow down, please. Thank you.
In the alternative, Mr. Kony is charged with ordering and inducing these crimes pursuant to Article 25(3)(b). Charges 15 to 29 concern crimes committed by Mr. Kony as an indirect co-perpetrator jointly with and through RA fighters pursuant to Article 25(3)(a) against women and children throughout the charged period. In the alternative, Mr. Kony is charged with ordering and inducing these crimes pursuant to Article 25(3)(b). Charges 30 to 39 concern crimes committed directly by Mr. Kony pursuant to Article 25(3)(a) against 2 females, identified as Victim 1 and Victim 2 during the charged period. The crimes charged in relation to the attacks on the Luala School and the 7 IDP camps between about 10 October 2003 and 8 June 2004 are the following. Count 1. Intentionally directing attacks against the civilian population as such as war crime punishable under Article 8.2 insofar as during the attacks on the Luala Girls' School and the 7 IDP camps, the LRA intentionally directed acts of violence against the resident civilian population not taking active part in hostilities. Count 2. Murder as crime against humanity, punishable under Article 7.1a, and Count 3. Murder as war crime, punishable under Article 8.2ci, insofar as the RA killed at least 618 civilians at the 7 IDP camps who were taking no active part in the hostilities. Count 4. Attempted murder as a crime against humanity, punishable under Articles 7.1a and 25.3f, and Count 5. Attempted murder as a war crime, punishable under Articles 8.2ci and 25.3f, insofar as the RIA targeted for killing at least 194 civilians at 6 of the IDP camps, namely Abia, Balogno, Odek, Pagak, Lukodi, and Abok, who did not die due to independent circumstances and who were taking no active part in the hostilities. Count 6. Torture as crimes against humanity, punishable under Article 7.1f, insofar as the RA inflicted severe physical and mental pain and suffering upon at least several hundred civilians abducted during and in the aftermath of the attacks on the Luala Girls' School on 6 of the IDP camps, namely Pajule, Abia, Odek, Pagak, Lukodi, and Abok. Count 7. In the alternative to torture, other inhuman acts, severe abuse, and mistreatment as a crimes against humanity punishable under Article 7.1k, insofar as the RA inflicted great suffering and serious injury to body and to mental and physical health of at least several hundred civilians, as described under Count 6. Count 8. Torture as a war crime punishable under Article 8.2ci, insofar as the RA inflicted severe physical and mental pain and suffering upon at least several hundred civilians, as described under Count 6, who were taking no active part in the hostilities, and for the purposes of intimidation, coercion, and discrimination. Count 9. In the alternative to torture, cruel treatment as a war crime, punishable under Article 8.2ci, insofar as the RA inflicted severe physical and mental pain and suffering upon at least several hundred civilians who were taking no active part in the hostilities, as described under Count 6. Count 10. Enslavement as a crime against humanity, punishable under Article 7.1c, insofar as the RA exercised powers attaching to the right of ownership over at least 100 of civilians abducted during and in the aftermath of the attacks on the Luala Girls' School and 6 of the IDP camps, namely Pajule, Abia, Odek, Pagak, Lukodi, and Abok. Count 11. Pillaging as a war crime, punishable under Article 8.2e5, insofar as the RRA fighters intentionally deprived and appropriated for private or personal use food supplies, livestock, and other property from the homes, shop, and other facilities of civilians living at the Luala Girls' School and the 7 IDP camps without the consent of the owners. Count 12. Destroying the enemy's property as a war crime, punishable under Article 8.2.12, insofar as the RRA destroyed homes, shops, and other facilities used by and belonging to civilians living at 5 of the IDP camps, namely Abia, Balonyo, Pagak, Lukodi, and Abok, which was not required by military necessity. Count 13, persecution as a crime against humanity punishable under Article 71H on political grounds of civilians of the 7 IDP camps perceived by the LRA as being affiliated with or supporting the Ugandan government based on the facts underlying count 1 to 12. Count 14, persecution as a crime against humanity punishable under Article 71H on age and gender grounds of at least 70 schoolgirls from Rwala Girls' School based on the fact underlying counts 1, 6, 7, 8, 9, 10, and 11. The crimes committed against women and children in northern Uganda throughout the charged period are the following. Count 15, enslavement as a crime against humanity punishable under Article 7(1)(c), insofar as the RRA exercised powers attaching to the right of ownership over at least thousands of children and women in the RRA. Count 16, forced marriage as an inhuman act as a crime against humanity punishable under Article 7(1)(k), insofar as the RRA inflicted great suffering and serious injury to body and mental and physical health by imposing a forced conjugal union on at least 100 of girls and women in the RRA. Count 17, rape as a crime against humanity punishable under Article 7(1)(g), and count 18, rape as a war crime punishable under Article 8(2)(e)(6), insofar as the RRA raped at least hundreds of girls and women in the RRA. Count 19, torture as a crime against humanity punishable under Article 7(1)(f), insofar as the RRA inflicted severe physical and mental pain and suffering upon at least thousands of children and women in the RRA. Count 20, in the alternative to torture, other inhuman acts, severe abuse, and mistreatment as a crime against humanity punishable under Article 7(1)(k), insofar as the RRA inflicted great suffering and serious injury to body and to mental and physical health of at least thousands of children and women in the RRA. Count 21, torture as a war crime punishable under Article 8(2)(ci), insofar as the RRA inflicted severe physical and mental pain and suffering upon at least thousands of children and women in the RRA who were taking no active part in the hostilities and for the purposes of intimidation, coercion, and discrimination. Count 22, in the alternative to torture, cruel treatment as a war crime punishable under Article 8(2)(ci), insofar as the RRA inflicted severe physical and mental pain and suffering upon at least thousands of children and women in the LRA who were taking no active part in the hostilities. Count 23, persecution as a crime against humanity punishable under Article 7(1)(h) on the grounds of gender and age based on the facts underlying counts 15 to 22, 25 to 29 of at least thousands of children in the LRA. Count 24, persecution as a crime against humanity punishable under Article 7(1)(h) on the grounds of gender based on the facts underlying counts 15 to 22, 27 to 29 of at least thousands of women in the LRA. Count 25. Conscripting children as a war crime punishable under Article 8(2)(e)(7), insofar as the LRA conscripted at least thousands of children under the age of 15. Count 26. Using children to participate actively in the hostilities as a war crime, punishable under Article 8(2)(e)(7), insofar as the LRA used at least thousands of children under the age of 15 to participate actively in hostilities. Count 27. Sexual slavery as a war crime, punishable under Article 8(2)(e)(6), insofar as the LRA exercised powers attaching to the right of ownership over at least thousands of girls and women in the LRA, and causing them to engage in one or more acts of a sexual nature. Count 28. Forced pregnancy as a crime against humanity, punishable under Article 7(1)(g), and Count 29. Forced pregnancy as a war crime, punishable under Article 8(2)(e)(6), insofar as the LRA perpetrators confined and made forcibly pregnant at least hundreds of girls and women. Mr. Kony is criminally responsible for the charged crimes contained in Count 1 to 29 by committing such crimes jointly with his co-perpetrators and through the LRA fighters pursuant to Article 25(3)(a). At least between 1st of July 2002 and 31st of December 2005, Kony shared a common plan or agreement pursuant to Article 25(3)(a) with Vincent Otti, members of Control Altar, and the LRA brigade commanders to attack civilians in northern Uganda whom the LRA perceived to be supporting the Ugandan government, and to sustain the LRA by committing the charged crimes, including systemic crimes against children and women abducted and integrated into the LRA. Mr. Kony and his co-perpetrators implemented this common plan through the hierarchically organized structure of the LRA. Kony made the following essential contributions to the charged crimes. 1. Regularly ordering LRA units to attack, kill, and mistreat civilians perceived to be supporting the Ugandan government and to destroy or steal civilian property. 2. Making strategic decisions regarding the manner, intensity, and focus of attacks against civilians in northern Uganda. Maintaining the system of abductions during the charged period and issuing orders to all LRA to abduct civilians. 4. Devising and enforcing the LRA rules for the mistreatment of women and girls. 5. Personally using children as escorts and abducted women and girls to act as domestic servants and as forced conjugal partners. 6. Devising and maintaining the LRA disciplinary system as such and motivating LRA commanders through rewards and threats to conduct LRA operations. 7. Deciding the command structure and promotions, demotions of LRA commanders and the transfer of fighters between units. And 8. Deciding on the allocation of supplies, including weapons and ammunition within the LRA. At the time of his contributions, Mr. Kony meant to engage in the charged conduct and intended, or was aware, that the charged crimes would occur in the ordinary course of events. Kony was aware of the criminality of the common plan and that the crimes would be committed in the ordinary course of events as a result of its implementation. Kony was also aware of the features of the LRA, including its organized and hierarchical structure, that allowed him and the other co-perpetrators to have joint control over the crimes. In the alternative, Mr. Kony is criminally responsible for ordering and inducing the commission of such crimes by the LRA perpetrators pursuant to Article 25(3)(b). Kony meant to engage in this conduct and was aware of his position of authority and influence over the physical perpetrators of the crimes. He intended the crimes or was aware that the crimes would be committed in the ordinary course of events as a result of the implementation of the orders or as a result of his acts or omissions. At all material times, Mr. Kony and the LRA perpetrators carried out all physical elements of the specific crimes charged and possessed all attendant mental elements. Mr. Kony is further criminally responsible for the charged crimes contained in counts 30 to 39 by individually committing the following crimes against 2 females pursuant to Article 25(3)(a) during the charge period. Count 30. Enslavement as a crime against humanity punishable under Article 7(1)(c), insofar as Mr. Kony exercised powers attaching to the right of ownership over victim 1 and 2. Count 31. Forced marriage, an inhuman act as a crime against humanity punishable under Article 7(1)(k), insofar as Mr. Kony inflicted great suffering and serious injury to body and mental and physical health by imposing a forced conjugal union on victim 1 and 2. Count 32. Rape as a crime against humanity punishable under Article 7(1)(g). And count 33. Rape as a war crime punishable under Article 8(2)(e)(6), insofar as Mr. Kony raped victims 1 and 2. Count 34. Torture as crimes against humanity punishable under Article 7(1)(f), and count 35. Torture as a war crime punishable under Article 8(2)(ci), insofar as Mr. Kony inflicted severe physical and mental pain and suffering upon victims 1 and 2, who were taking no active part in the hostilities for the purposes of intimidation, coercion, and discrimination. Count 36. Sexual slavery as a war crime punishable under Article 8(2)(e)(6), insofar as Mr. Kony exercised powers attaching to the right of ownership over victims 1 and 2, causing them to engage in acts of sexual nature. Count 37. Forced pregnancy as a crime against humanity punishable under Article 7(1)(g), and count 38. Forced pregnancy as a war crime punishable under Article 8(2)(e)(6), insofar as Mr. Kony confined and made forcibly pregnant victim 1. Count 39. Persecution as a crime against humanity punishable under Article 7(1)(h) on age and gender grounds, based on the facts underlying counts 30 to 38 of victims 1 and 2. Kony committed these crimes with the requisite intent and knowledge. At all material times, Mr. Kony carried out all physical elements of the specific crimes charged and possessed all attendant mental elements.
Thank you very much, Court Officer. All right. I turn now to the parties on the issue of Rule 102. 22-3. The prosecution and defense both had the opportunity to submit written observations pursuant to this rule on matters that could not have been brought to the attention of the chamber at an earlier stage of the proceedings. The chamber gave a date for the receipt of such observations, and it was the 22nd of August, 2025. The prosecution and defense did not provide any such observations, which of course was their right. Can the parties confirm that they do not wish to bring any such matters and that we can proceed with the opening statements? Defense?
Your Honour, we can so confirm.
Very well, thank you. Prosecution? The microphone was not on.
Aucune observation du côté du procureur.
We have no observation to make from the side of the prosecution.
Thank you. In that case, then, we proceed to the prosecution's opening statement. Prosecution, keep in mind, you have 30 minutes.
Mesdames, les juges,
Your Honours,
vous avez accepté de tenir
you have agreed to hold
confirmation des
this confirmation of charges hearing
Joseph
against Joseph Kony.
le banc du suspect, accusé potentiel,
The dock
est vide.
is empty
Joseph Kony
of any potential accused. Joseph Kony is not present here today.
20 ans,
20 years ago, other judges of this court issued a warrant of arrest against him.
depuis 20 ans, il est recherché.
He has been at large for the last 20 years,
Il s'est
and
soustrait
for the last 20 years, he has managed to evade
cette
justice.
justice internationale à laquelle
This international justice that the government of Uganda and the many victims,
du nord de l'Ouganda,
particularly in northern Uganda, have sought,
de pouvoir rendre cette justice.
as they were unable to render justice in their own country.
Nous avons tout fait.
We have done
Nous avons tout
everything we can.
pour nous hisser
We have done everything we
à
can
hauteur de cette
to live up
responsabilité
to the
importante.
important responsibility that,
Les membres
on the one hand,
fondateurs
the
du
founding
Procedural,
members of the Rome
d'autre
Statute,
part,
and on the other,
les
the
bénéficiaires
beneficiaries
de la justice que ce
of
traité
the
postule,
justice that this statute postulates,
responsabilité qu'ils ont placée en nous.
have placed in us.
Hélas,
Unfortunately,
les tentacules
the
de la
tentacles
justice pénale
of
internationale,
international criminal
ces
justice,
tentacules bien longues
even though
de la
lengthy,
coopération des États, signataires ou
with
pas,
the cooperation of states, whether they be signatory to the Rome Statute or not,
pas pour
have
assurer
not been sufficient
l'arrestation
to ensure
rapide
the
des fugitifs.
swift arrest of
Beaucoup de
fugitives.
victimes qui
Many
ont la
victims
fortitude
who
de
had
survivre
the
aux
strength to survive the horrors of a devastating civil war
actes n'ont malheureusement
have
pas survécu à cette
unfortunately
longue attente,
not survived this lengthy wait.
ont perdu
Others have lost patience,
patience, mais il en reste toujours
but there are still those who,
contre vents et
against all odds,
marées, ont attendu.
have waited for this very moment.
Et c'est pour toutes ces victimes
And it is for all these victims that it is important
audience aujourd'hui,
for this hearing
demain et d'après-demain, que cette audience,
to be held today, tomorrow, and the day after that.
cette audience,
This hearing,
Madame la
Madam President, as you reminded us at an earlier stage, is not a trial in absentia. The right of a person to be present at their trial and to challenge the charges against them is a sacred right, as we know. However, without in any way altering this right, our statute, as you also reminded us, in certain circumstances allows that the suspect does not frustrate by their own will the confirmation of charges against them, in particular by choosing not to respond to the summons of the court. So, it is by virtue of this mechanism, Article 61, paragraph 2, which, as you reminded us, has never been used before. You will be using this, ladies and gentlemen of the bench, to examine the 39 charges brought against the ICC's longest-standing fugitive. These charges that you have just heard read out before the court. These crimes, whose victims include men, women, children, and young girls, will forever remain part of the dark pages of Uganda's history. These crimes include murder, different forms of slavery, rape, inhuman and degrading treatment, and many other acts that the prosecution intends to present at this hearing on the merits. The crimes were committed by an armed group, the Lord's Resistance Army, to which I shall refer to using its initials, the LRA. And in English, it is known as the Lord's Resistance Army. So these crimes were committed by the LRA under the orders of Joseph Kony. Your Honours, Joseph Kony, whom we see here in this photograph, has always been the leader of the LRA, upon which he imposed his cruel vision. He also moulded the group to his own image. It was a true army, a new society that he set up to exploit the young men and women from northern Uganda, young people who were brutally abducted in order to swell its ranks. Girls and young women have been enslaved and subjected to forced pregnancies, whilst the boys were forcibly recruited to fight the Ugandan army. The vicious circle of this criminality meant that the victim became the executioner or the perpetrator, as this court has witnessed in a previous such case. Joseph Kony never wavered in his role. He remained the main perpetrator until the very end, a role that he assumed and exercised with full knowledge of the fact. He is over 60 years of age today, but still on the run, despite all efforts to bring him to justice. And it is in this particular context that the prosecution considered that a confirmation hearing in his absence was justified. This hearing, in our opinion, will advance the proceedings in a tangible way. And this hearing, if, Your Honours, the charges are confirmed, it will allow the proceedings to move rapidly to the next stage as soon as Joseph Kony is arrested and surrendered to the court. And we are not despairing. Your Honours, the events that led to this hearing are unprecedented. The charges against Joseph Kony relate to serious events that took place in northern Uganda between the 1st of July 2002 and the 31st of December 2005. The LRA has been carrying out its criminal activities in this part of the country since the 1980s. This armed group was first known under the name of the Holy Spirit Movement before being renamed as the LRA. And it was within this movement that Joseph Kony effectively rose to power. From 1988, he organized and led this armed group. Kony's forces then waged a guerrilla-type insurgency against the government in power. The armed conflict lasted throughout the 1990s, despite a number of peace initiatives. An extract from the testimony of P0422 has been provided to the Chamber, and this excerpt gives a detailed account of the historical context and background of the LRA. And may I refer you to ERN UGA-OTP-000000966 and 967. I will now review some of the elements of the chronology of this case. The UPDF, that is to say the Ugandan government army, retaliated against the LRA by setting up the Iron Fist operation, Operation Iron Fist, which started officially in the year 2002. The LRA bases in Sudan were then destroyed and hundreds of individuals were killed. Joseph Kony escaped capture. After this operation, most of the LRA units and their elements returned to Uganda. And it was in this context that on the 14th of June 2002, Uganda ratified the Rome Statute. In January 2004, Uganda, that is to say, a member of the ICC at this point, referred the situation to the ICC. When the investigation began in July 2004, the war and the crimes attributed to the LRA were ongoing, and the office was operating in difficult terrain. At the time, many sites were inaccessible. But despite all these challenges, the office was able to gather enough evidence to request the issuance of an arrest warrant, which was initially under seal, against Joseph Kony, issued on the 8th of July 2005. Arrest warrants were issued against other senior LRA leaders, such as Vincent Oti, who died in 2007. There is also Raska Lukuya, who died in 2006, as well as Okot Odiambo, who died in October 2013, and Dominic Ongwen, who was tried by this court. These are the first arrest warrants to be issued by the ICC that were subsequently made public on the 13th of October 2005. Kony is charged with 33 counts of war crimes and crimes against humanity. Your Honours, the tireless efforts of the Office, in conjunction with the Registry and its partners, to secure the arrest and surrender of the fugitive, have to date proven unsuccessful. From the 1st of June 2006, an Interpol Red Notice was issued, and it remains active today. Other initiatives have followed many other initiatives. Requests for the arrest of Joseph Kony were sent to several states. In October 2008, the European Parliament requested for a plan to be put in place for the arrest of Joseph Kony. In 2012, African Union troops were tasked with searching for Joseph Kony. It was Europe and it was also Africa. And even American troops joined the search. For years, the Ugandan government army made concerted efforts to apprehend Joseph Kony. Civil society organizations launched public campaigns to facilitate his arrest. These same efforts are ongoing today and are not expected to cease until Joseph Kony has been arrested. I will now review some important elements of the proceedings in this case. In January 2015, Dominic Ongwen, commander of the Sinya Brigade, surrendered.
The judges separated his case from that of Joseph Kony, and his trial was held between 2016 and 2019. Dominic Ongwen was found guilty on the 4th of February 2021, and he was sentenced to 25 years imprisonment on the 6th of May 2021. His sentence was upheld on appeal on the 15th of December 2022. After 20 years of searching in vain, we now ask you, Your Honours, to confirm the charges in the absence of the suspect. Through the 39 counts of crimes against humanity and war crimes brought against Joseph Kony, we have sought to cover the systemic criminal activity of the LRA during the reference period. But that doesn't mean that we have been able to exhaustively list all of the crimes. That just isn't possible, but at least those that were the most emblematic, those are the ones that we have submitted. Now, Your Honours, the case against Joseph Kony concerns systemic violence inflicted on Ugandan citizens in northern Uganda. This violence was perpetrated by the LRA under the command of Joseph Kony. The citizens of northern Uganda had no choice but to abandon their homes and possessions. They lived in constant fear of attacks and abductions. The impact of LRA attacks on children in northern Uganda has been particularly severe. Fearing attacks and abductions, thousands of children every night had to flee their villages to seek refuge in towns such as Gulu. They travelled at night without their parents just to stay safe. The video appearing on your screens is an excerpt from a documentary released in July 2006 by Journeyman Pictures. This excerpt illustrates the LRA's violent campaign against children, and it is recorded under ERN UGA OTP 00001369 1132 to 1208. The faces of the children you see on screen have been blurred.
The next morning, the kids, cold and tired, began to return to their villages. Children who spend their lives in fear.
The repercussions of this unprecedented violence continue to be felt today. Scarred in their body and spirit, survivors still struggle to recover from the ordeal they endured. The social and cultural fabric of northern Uganda has been torn apart, and it is still struggling to rebuild itself. In addition to the abduction of children, there have been attacks on civilians in camps for displaced persons. Civilians were effectively placed in camps for displaced persons within the framework of the counter-insurgency strategies adopted by the Ugandan government, which consisted of removing civilians from rural areas and resettling them in towns and later in camps for displaced persons. At the height of the crisis in 2004, almost the entire population of northern Uganda, or 1.5 million inhabitants, were living in camps for displaced persons, as is attested to in the report at ERN UGA OTP 0044 0044 and page 51 thereof. In the meantime, the LRA grew into an army of several thousand fighters receiving significant support of Sudan. It has established base camps in southern Sudan and receives weapons and military training from the Khartoum government. And here I refer you to ERN UGA OTP 00000966 at page 52 thereof. Even after Operation Iron Fist in 2003 and 2004, LRA violence continued to focus on refugees in camps for displaced persons in northern Uganda. Now, my colleague Melissa Timms will tell you later about the LRA's attacks on several camps for displaced persons. She'll tell you about the pillaging, murder, torture, serious exactions, abuses and abduction of civilians by this armed group. More than 600 civilians were killed in the attacks, purely covered by the charges alone. But the number of unidentified victims is much higher. The Ugandan authorities recorded the moments following one of these attacks. This is an excerpt from the Barlogno attack, which we will hear an excerpt from. You will see Ugandan police officers conducting forensic examination. We have chosen an excerpt that does not allow for the identification of the people filmed. It is at UGA OTP 0021-0012 and in particular minutes 4:03:23 to 04:36:18.
Vous verrez que des représentations graphiques de restes.
You will see graphic depictions of human remains in this excerpt. Our office's Scientific and Technical Analysis Unit analysed these recordings along with other evidence in order to identify the victims. The results of the analysis are set out in the annex to our pre-confirmation brief. The prosecution contends that the LRA considered refugees in the displacement camps to be enemies. Joseph Kony accused them of supporting the government of President Museveni. His motto was clear: if you are not with us, you are against us. And my colleague, the team leader, Leonie van Braun, will explain to you in greater detail the key role that Joseph Kony played in the attacks on these camps. Your Honours, Joseph Kony established a system of abducting men, women and children in northern Uganda. The LRA forcibly abducted thousands of people and enslaved them during the period covered by the charges. The abducted women were subjected to multiple forms of enslavement. They were forbidden to leave the LRA. Partners were imposed on them. They were subjected to rape and other forms of sexual violence. They were subjected to reproductive control, including forced pregnancies, which forced them to give birth in the bush without prenatal or postnatal care. And they were subjected to exploitation, aggravated by labour in conditions of domestic servitude. Within the LRA, these women were referred to as wives, a euphemism for forced conjugal partners and domestic slaves. Children were not spared either. Kony abused their innocence, as well as their inexperience, to swell the ranks of his army. He set up a veritable army of child soldiers. And perhaps I will show the last video. Boys and girls, sometimes under the age of 18, were abducted and enlisted into the LRA. Some were abducted on their way to school or from the fields. They were forced to become soldiers or reduced to being childminders or sex slaves. And this is the picture that I'm going to present to you. It presents a protected witness, and for that reason, this part cannot be shown to the public.
Donc, vous pouvez voir sur vos écrans une photo du témoin.
So you can see on your screens a photo of witness P0275, who was abducted at the age of 9 in 2004 during one of the attacks covered by the charges. And this witness, P275, stated, and here I quote, "During the period when I was held captive by the LRA, I saw children younger than me being trained to shoot with weapons. I knew they were so young because the muzzles of their AK-47 rifles dragged on the ground when they carried them on their shoulders." And here I refer you to ERN UGA OTP 0044 and page 3407 thereof. P0275 is just one example among thousands of children who suffered the same fate. The children suffered abuse, hunger, and thirst. Many of them died in captivity. In a radio interview in 2002 with the Ugandan radio station Mega FM, Joseph Kony and his deputy Vincent Otti admitted to implementing a policy of abducting civilians and young girls. And here is what Kony said: "As rebels, we do not kidnap children, but that is how we recruit." Otti followed the same line of reasoning. He said, "I want to ensure you that the girls we take in and send to the bush are our mothers. We always take young girls who are not infected with HIV, so that those who are infected with HIV remain among you." And here I refer you to the last ERN, namely UGA OTP 00230011, and namely pages 3 and 10 thereof. And now I'm going to finish, Your Honours, by stating that children have been deprived of their fundamental rights, their right to health, education and freedom. Their childhood has been stolen from them. Joseph Kony remains untraceable within the meaning of the statute. Today's hearing is a very important step in the administration of justice. The prosecution has only been able to bring the case to this stage of the proceedings thanks to the courage of the victims and affected communities. It is also thanks to the excellent cooperation of the Ugandan authorities, traditional leaders, states, organizations, and all partners. Continued cooperation is crucial to bringing Joseph Kony's flight to an end for once and for all. Kony's arrest and surrender should allow the next phase of this case to begin, and if the charges are confirmed by the Chamber at the end of this hearing, as we request, Your Honours, I would like to thank you for your patience and for your attention.
Thank you very much. CLRV representatives, we have 10 minutes. Would you propose to start?
Thank you, Madam President. I think it is best to do the whole presentation at once, and I would suggest that we take the break and I start after the break.
We find that acceptable, so that we will take the break now. It's a bit early. So we compute 30 minutes from now, which would be 20 after 11, and we will return to hear the CLF. All right then, shall we?
All rise. We will away.